We're recording. Okay, it is 9 a.m. on October 26th, 2022. This is a public deliberation of the Baltimore County Board of Appeals in the matter of Raymond and Sandra Frank and the Inverness Brewing, LLC in case number 19-541 SPH. On 4 motions for reconsideration filed by Michael McCann on behalf of the petitioners Samuel and Michaeline Yaffe and the Sparks Glencoe Community Planning Council, by Mark DeShiel on behalf of Carolyn Owens, by Richard Reinhardt on behalf of himself and his wife, and by Carol D'Amelio, Deputy People's Counsel, asking us to focus on a number of issues in the order in this matter, which was issued on August 26, 2022. And these motions were timely filed. I have gone through all of them and have identified a number of issues, which I'll sort of summarize for you, and then we can discuss them. One involved the parking that should have been, according to Mr. McCann, deemed as a violative of the special exception plan as an unauthorized amendment. Both Mr. McCann and Mr. DeShiel had issues with the word loud as to describing music. Mr. McCann and Mr. Reinhardt felt that the amended plan should require a further hearing. Mr. DeShiel succinctly asked for 2 changes. One, to delete the word Miss Owen as a protestant early on, and to clarify on the music is not be amplified music is not being permitted. People's Council adopted some of these arguments and referred us back to their original post-hearing memorandum. And the last issue raised by Mr. McCann had to do with the definition of an event. He thought the distinction we made was not a meaningful distinction, and that there should be objective criteria on which to determine and distinguish an event from a regular business hour, the conduct of business during regular hours. Did you see any other issues that we should address?
I did not.
No, not substantively, but at the risk of being out of line, I would add as an issue the basis or standard for moving for reconsideration must be addressed before concerning ourselves with the specific issues that the parties raised. In other words, in my view, before we get there, has there been any material and adequate offering of newly discovered evidence, change in law, and or fraud, mistake, or irregularity? And if not, I don't believe we need to address any of them. But to the extent we need to go through individually and determine if each meets that standard, okay. But I don't think it's in the nature of a dialogue, the way these motions set up, that we decide whether we delete a word, add a word, reconsider, yet again, a difference of opinion on interpretation. If we're wrong, the circuit court will make that determination if one or more of the parties take it to the circuit court. But I don't think we get there. I just want to add that before we go through all of these individually.
I think to some extent there were allegations that we made a mistake of law as to the parking as being violative of the special exception, and as to the requirement that there be a further hearing on an amended site plan. Though
I'm not sure if that, I'm sorry, I'm not sure if that's what mistake in this context means, but I'll stand down and we'll go through them one by one.
Okay. Well, let's start with the parking. And I'll say I disagree with Mr. McCann's interpretation and would not amend our ruling on that issue.
I agree, Madam Chair.
Concur.
As to the music, I'm happy to delete the word loud if that'll make people happy. Was certainly our intention not to allow amplified music, and rather than be vague about it, you know, I don't want to be misconstrued in this and think it's a nitpick, but yeah, I'm willing to go along with it.
So procedurally, I believe the intent also was to not allow any amplified music. And so the issue of that word seems to have created room for disagreement. Procedurally, what I think that really means is it's been brought to the board's attention, and the board would do what? Supplement or reissue a corrected opinion as opposed to granting a motion for reconsideration on that point? Or is it your view that we're granting a motion for reconsideration on that point to make that correction?
Well, I think procedurally, if it was raised in a motion, we should rule on the motion as to that point.
Okay, I just don't think that meets the standard for reconsideration, which is why I bring it up. But I don't know. My concern in these cases is that whether it's a party involved or another party, attempt to use what we do on the facts and circumstances in a given case to argue a precedent in other cases. And I don't want it to be construed that the board is going to take motions for reconsideration. Maybe it's done this in the past when I haven't been on this board. To change the wording. I mean, this is something I believe we could do sua sponte on our own, because it's been brought to our attention, there's a word missing. I don't know the proper way to handle it, and I don't want to create more conflict, but I do see how these things are used.
You're suggesting issuing a corrected opinion?
Yes, because I do think the intent, I don't know how far we're going to go anywhere else, but I do think the intent was to not allow amplified music. So none of us seem to have picked up on the significance of that word loud being used. So I see why we would remove it. And I think it might be the better way for us simply to correct it, but we're here to deliberate and talk about it. So I don't know the answer, but I know the issue.
Let me just respond. If it's not going to be amplified music, how loud is it going to be? You know, it's just from a practical term. So I didn't see it in some ways inconsistent, to be quite honest with you. If we're not gonna allow amplified music, I mean, and they're playing from the barn, and we saw the distance in between, we considered all of that. I mean, how loud is it really gonna be? I'm not as troubled by the word loud, to be honest with you.
I would say I agree with you entirely, but for the sake of clarity, I would rather be clear about it and just take it out.
Okay,
All right.
okay with that.
And let me just put a finer point on what I'm trying to articulate. By taking that word out, I don't believe that the board is reconsidering its decision. What I think it's doing is clarifying what it intended to write in the first place. There's no change in what was stated in the deliberation, I believe.
And I agree. As to the amended plan requiring a further hearing, I don't think that's necessary in this instance. That's why they were before us.
I agree.
Agree?
As to apparently a factual misstatement about Miss Owens, I would think that would fit with correcting our opinion and deleting her name on page 12 as having been in opposition. And that was simply, I think, a mistake on our part.
Yes,
I'm fine with that.
And then the question of the definition of an event. I think that we narrowed an event based on what was the limitations that were articulated by statute. Mr. McCann argues that an event should be defined by objective criteria. I think the criteria we imposed is objective, if rather limited. And I appreciate his position. I'm not sure that fits into the framework of a motion for reconsideration as articulated by Mr. Sampson. And I'm not sure that it is not entirely a question that should be addressed by legislation rather than by us. I don't know what your thoughts are.
My view is that we considered the evidence. We had expert testimony, we had lay testimony. Where we landed is consistent with some of the testimony, Mr. Addix, Mr. Frank, and I don't see that there's any appropriate basis for us to have to reconsider that. If the one or more parties disagree with that conclusion, they have remedies to seek, and if we're wrong, then that will be determined elsewhere. I have no problem with what we relied on and deliberated on and how we reached our conclusion based on the testimony presented. So I would not reconsider this and make any change.
Nor would I.
nor would I.
So then I think we're in agreement that the two corrections we'll make are those rather succinctly asked by Mr. DeShiel and by certainly as to the music by Mr. McCann. And otherwise, and we'll issue that as a corrected opinion, not a grant of a motion. At that point, the the motions are denied. And I think procedurally that covers what we have to cover. And substantively.
I agree.
I concur as well.
And that will conclude this deliberation. And thank you, everyone, for your participation.
Thank you.
Thank you for chairing again, Madam Chair.
You're very kind. Thank you.
Providing a great opinion also, Madam Chair. I know it was a lot of work, a lot of time. Thank you.
Well, obviously it didn't please everyone. We'll fix it and go from there. I'm going off the record and concluding this deliberation. Thank you, gentlemen.
Thank you.
Thank you.